It is further evident that he has castigated the junior engineer also in his report as responsible for the lapse to the extent of 50% and has held the petitioner liable for remaining 50% of the loss of public funds. He has also recommended a wording of censure entry and stopping of one increment each of the petitioner as well as the junior engineer concerned, without naming him. However, the punishment order dated 22nd October 1993 passed by the respondent number 1, executive engineer does not records any finding regarding the junior engineer nor it apportions the loss of public money between the petitioner and the junior engineer concerned. Even the punishment order does not shows any consideration of the reply submitted by the petitioner to the charge sheet, wherein he stated that the cultivators concerned have given their affidavits stating that their borings were duly installed by the petitioner. One cultivator, Raghunath, stated that due to family dispute, he has installed the boring in his well instead of the place where it was installed by the petitioner and his team. Not only the defense of the petitioner was ignored, also no witness was called by the inquiry officer for recording statement nor the petitioner was afforded any opportunity to produce his witnesses or to cross-examine the witnesses of the prosecution. The undisputed fact herein is that the matter pertains to the mutation of the land in question. The order for mutation has been passed by the original authority in favor of the writ petitioner. The private respondents, being aggrieved with the said order, had preferred appeal before the appellate authority has quashed and set aside the order passed by the original authority against which the writ petitioner had preferred revision before the additional collector, Khunti, being mutation revision case number 15 R15 of 2012. Which has been dismissed by confirming the order passed by the appellate authority wide order dated 20th February 2013, against which the present writ petition has been filed. The sole ground has been taken by the petitioner that the additional collector has not been conferred with power to exercise the power of revision under Section 16 of the Act, 1973. Therefore, the order passed by the additional collector, being nullity, is not sustainable in the eye of law. It is the solemn duty of the court to apply the correct law without waiting for an objection to be raised by a party, especially when the law stands well settled. Any departure, if permissible, has to be for reasons discussed, of the case falling under a defined exception, duly discussed after noticing the relevant law. In financial matters, grant of ex parte interim orders can have a deleterious effect, and it is not sufficient to say that the aggrieved has the remedy to move for vacating the interim order. Loans by financial institutions are granted from public money generated at the taxpayer's expense. Such loan does not become the property of the person taking the loan, but retains its character of public money given in a fiduciary capacity as entrustment by the public. Timely repayment also ensures liquidity to facilitate loan to another in need by circulation of the money and cannot be permitted to be blocked by frivolous litigation by those who can afford the luxury of the same. The writ petition ought not to have been entertained, and the interim order granted for the mere asking without assigning special reasons, and that too without even granting opportunity to the appellant to contest the maintainability of the writ petition, and failure to notice the subsequent developments in the interregnum.